Hi, everybody. I hope you're having a good afternoon. I couldn't even remember if it was evening or afternoon because I've just been like studying. Um, but today, well, I take the bar exam in just a couple of days. And so I'm drilling a lot of questions right now and just making sure that I have things memorized that I should. Um, I was really not feeling bar prep, so I decided to come online and see if anyone wants to supervise me while I study. Um, we're going to do a bunch of different topics today, probably. Um, what I'm doing right now is I'm going to go through all the questions that I've missed before in practice and try re-answering them again and make sure that I know the reason why they were wrong. I really hate this part of practice, but we have to do it. So I'm going to pull up all my incorrect questions and we'll go through them and make sure that I know why I got um, them wrong. Hey, CH, thank you. I need supervision so badly. It's really hard in the days leading up. And most people by now are just like relaxing, but I am a backwards worker where I like to um, do a lot of the practice right before. I say like, but okay. So, like I said, these are questions that I have answered incorrectly, so they're going to annoy me, but I don't remember usually what the right answer is. So we'll just see if I remember it, and if I don't, then I'll memorize the rule. Okay, so this first question I have is about granting a motion to dismiss. Okay, so it's asking about a motion to dismiss for um well, there's a lot of reasons you can file a motion to dismiss. They're saying it violates the statute of frauds. And the statute of frauds is basically a rule where some contracts have to be written. So contracts that like well, marriage certificates and like a marriage, like what is it, prenups, those have to be written. Sales of land have to be written. If you are guaranteeing somebody, like if someone has bad credit and you're signing on to like back up their money, that has to be in writing. If it's a contract that will last longer than a year, it has to be in writing. And if it's a contract for goods over $500, it has to be in writing. Um, okay, but anyway, let's see what this one is about. So this is about a bakery. A bakery negotiated with a supplier regarding, okay, they negotiated with a supplier to get flour. Um, Bakery negotiated with a flour supplier, um, agreed to terms to be written down, but the supplier never signed the written contract. But supplier um, still began providing flour to bakery. Okay, so if you right away, that makes me think if you have an agreement, and even if you don't have a contract when you were supposed to, if you start acting like you have a contract, then sometimes courts will say that you do. So since they started giving the bakery flour, that makes me think they're acting like they have a contract. Okay. Um 6 months later, the price of flour rose dramatically. And um the supplier, realizing it had never signed the contract, told the bakery it would have to charge a higher price. Um, the bakery filed a lawsuit for a breach of contract because, well, if they had a contract, there's a certain price on it. And so the supplier just demanding more money goes against the contract. The supplier filed an answer in which it denied the factual allegations regarding the price and duration, but did not raise any defenses. The following day, the supplier filed a motion to dismiss, asserting that the oral contract between the parties violated the statute of frauds. Okay, sorry. I know that I might not have made sense with the way I was reading it. Bakery filed suit for breach of contract. Supplier filed answer disputing price and duration, but no defenses, which means they didn't raise statute of frauds. And then supplier filed motion to dismiss. And in the motion, oh, well, that's not right. They brought up statute of frauds. Well, the statute of frauds, which is just like if someone says like statute of frauds, it just means like it should be a written contract. But that's a defense, and if they're going to raise it as a defense, I believe if they're gonna raise it as a defense, they have to do it in their answer. They can't do it in their motion to dismiss. So let me see if there's an answer choice. It's basically is asking, should they grant the motion to dismiss? What does A say? Yes, because denied allegations. Yes, because complaint failed to state a claim. No, because supplier, waived any objection by filing an answer. No, because supplier did not assert statute of frauds in its answer. Okay. I think it's going to be D because, well, let me just say that. Is it D? Yay. Okay. Good job. Good job. Okay. Thanks, guys. Let me check chat. That was like a lot of focusing for me. Oh, hey, guys. Hey, Andy. I'm so happy you're here. Oh, hey. Good. I'm glad you're still here too, CH. Yeah, so CH for this one, there was not a, well, they likely agreed on a price orally. Okay, awesome. Good job. Okay, have to raise affirmative defenses in answer. Not in motion to dismiss. Okay, so that's one thing that's a question that I got wrong before, so that's good. What I want to make sure. Okay, I have to raise affirmative, defensive, and compulsory. Not that this matters, but this is just for me. Okay, next question. Okay, this next one is about whether testimony is admissible. Whose testimony is it? Oh, I did this one yesterday. Okay. Okay, so what's happening in this one? A civil trial for fraud. The defendant claimed not to be involved. The plaintiff called a witness to testify that the defendant was involved. But the witness surprised the plaintiff and said the defendant was not involved. Then the plaintiff asked the witness whether they had previously told someone else that the defendant was involved. Counsel asked witness 1 if they had ever told witness 2 that defendant was involved. Witness 1 said no. Then the plaintiff called the second witness to testify that the first one had said over dinner that the defendant was involved. Okay, and then is witness 2 testimony admissible? Okay, let me see if you guys are saying anything. Hey, Olap. We're getting down to business over here because I take the exam on Tuesday and Wednesday. It's 6 hours each day, which is just too much. Oh, I love your little dance emoji. Okay, so this is about hearsay. When you have a hearsay issue, you want to think about who the declarant is, meaning like who the person talking. So here, the declarant is witness 1. If the witness is available for cross-examination, then it's usually allowable. Both witnesses here, well, maybe I should just look at the, okay, obviously need to go over the hearsay objections because I'm not entirely sure. So let me go over the answer choices. Well, okay, yeah, let me put up the answer choices. No, because can't impeach your own witness. No, because not a hearsay exception. Yes, but only to impeach first witness. Yes, to impeach first witness and prove the defendant's involvement. Okay. So hearsay is an out-of-court statement presented for the truth of the matter asserted. Okay. This is an out-of-court statement because it was said over dinner. The prosecution is not trying to prove, well, they're not offering the statement to prove that the defendant is involved. They're offering witness 2 to say that witness 1 said that the defendant was involved. So I think it's going to be answer choice C because they are bringing in witness 2 to impeach, and impeach just means you're challenging like the credibility of a witness. So they're bringing in witness 2 to counter witness 1 denying, saying the defendant was involved. I think. We'll see. I'm scared. Yay. Okay. Oh, Andy, you are right. It is civil. I was not even thinking civil. Yay. Okay. I do want to make sure I understood the reasoning right. Okay. Let me write down the reasoning here. Okay. This is what I forgot. So prior inconsistent statement, inadmissible to prove the truth unless, okay, are admissible to impeach a witness. Extrinsic evidence admissible only if the impeached witness could be examined. Okay, yeah. I actually did know that. Okay, next question. CH, hearsay objection exception is only with the opposing party. No, right. That's one of the exceptions. There are several exceptions to hearsay. One, what was I going to say? Opposing party is one. Like excited utterance is one. Your dying declaration is one. But yeah, you're exactly right. Opposing party is one. So like if it's something that the defendant said out of court or the plaintiff said out of court, then it can come in. It's not hearsay. I think the difference is statutory versus constitutional. Andy, Laura, I don't know either. I really don't know. At some point I just become a monkey and I just start memorizing. Um, yeah. Okay, that's good. Okay, this is about removing a federal judge. Okay. Can House of Rep remove federal judge? Well, to remove judges, federal judges, you can only do it by impeachment and by impeachment. They have tenure as long as they are on good behavior, and that's literally what it's called, good behavior. Yeah, that's basically it. So let's see what the House of Representatives is doing in this question. They created an investigatory committee. House created committee to look, I kind of remember this one, to look into judicial administration process. The committee was tasked with investigating, I don't know, like administrative things like scheduling with courts. The goal was to ensure that the processes were carried out efficiently and pursuant to federal legislation. Okay. After much investigation, they concluded that a federal district judge was negligently mismanaging trial schedule, causing undue delays. They made a recommendation to the House to remove the judge. Well, they can't do that. So my answer choices are no, because House can't investigate a federal judge. No, because federal judge removed only by impeachment. I'm pretty sure it's that one. Yes, because House can remove the judges with or without cause. That's also not true. Yes, because federal judge mismanaged trial schedule. No. Okay, pretty sure it is B. Please let it be B. Please let it be B. Please let it be B. Yay. Okay. Thanks, guys. I know I'm like flying through these, but it feels a lot better to have some supervision. Okay. Yep. Nice. All right. So I have, I guess, improved a bit since I did these questions last. That's good. Okay. This next question is asking about. Oh, I hate this. I know. Okay. Well, this one I remember the answer for, but okay. This is asking if something was a reasonable seizure. Oh no, I don't think I. Well, okay, anyway. Um, so for reasonable seizure, you basically have to have probable cause. Um, well, you have to have probable cause to get a search warrant, or if you are searching somebody for another crime and you come across evidence of a different crime and it's in plain view, you can still take it. Okay. This one's going to be a little rocky. So this was a vice principal at a high school, suspected that an 18-year-old student possessed legally prescribed but controlled medicine. Principal suspected student had legal medication, but against school policy. Principal did not have probable cause to search student. But believed they had a moderate chance of finding medication on the student. The student emptied pockets and principal found 3, it's basically Adderall and amphetamine, but 3 Adderalls, I think that's what amphetamine is, possessed illegally. Student charged with possession of okay, I guess I am going to spell it, amphetamine tablets. Student moves to suppress the tablets. Should court grant it? Well, let me put up the answer choices. So no, because the search was reasonable. No, because student didn't have reasonable expectation of privacy on school grounds. Yes, because lacked probable cause. Yes, because principal wasn't searching for amphetamine. Okay. So basically, if you don't have probable cause for a search warrant, like the general rule is basically like the search has to be reasonable. I remember this one. I'm pretty sure the search was reasonable. I just can't remember the exact rule they said, so I might as well just see it. Yeah. Okay, it was A, but I got to read the rule Y. Okay. Oh, this is why, because there's a special rule for schools, public schools. Well, let me write down that special rule. Student searches are reasonable when, if I had known this rule, then I would have been fine. When principal has moderate chance of finding expected evidence and search measures are reasonably related to the objective, the search, and not excessively intrusive. Okay. And illegal items seized are admissible even if they were not the reason for the search. Okay, so basically student search, reasonable, well, student search requires moderate chance of finding evidence and must be reasonable. Well, then that makes sense why the answer choice was they should not suppress the tablets because it was reasonable. Yeah, CH, I didn't know that one either, obviously. I only remembered it because, and like I remembered it because I didn't, but I remembered it because I got it wrong and I obviously didn't know that rule. And I definitely probably did not slow down to read it. So that one kind of counted, but not really. But got to make sure I remember that. I think I will. Student searches just have to have a moderate chance of finding evidence. And even if it's not the evidence you were searching for, if it was in plain view or seized properly, then it's still admissible. Okie dokie. Wow, it's only been 26 minutes. My brain hurts. Okay. Next one. All right. This is another one about a motion to dismiss. Oh, I hate these. This is for lack of personal jurisdiction. All right. Well, there's a lot of rules of personal jurisdiction, so I'm just going to go over the scenario first. So, a mechanic that lives in state A, was employed by a railroad company. He got in contact with asbestos and other chemicals. He did all of his railroad work in state A and state B. He retired and then was diagnosed with cancer attributed to his exposure to asbestos and chemicals. Sorry, I was drinking some caffeine. Later diagnosed with cancer. He sued the railroad company in Fed court in state C, under federal law. Okay, so if it's under federal law, that means it has subject matter jurisdiction, because there's two types. Well, there's different types, but in this scenario, there's subject matter jurisdiction and personal jurisdiction. I don't need to go into that. Okay. The railroad company is incorporated and principal place of business is in state A, registered to do business in states B, A, B, and C. State C requires any companies well, let me just do this. Requires companies to sorry, this is so confusing. Okay. A to consent to jurisdiction in their courts. Railroad company file no pre-answer motion and in its answer move to dismiss for personal jurisdiction. Okay. How should they roll? Okay, so for companies, Personal jurisdiction, which just means personal jurisdiction means where can you be brought in court. So basically, what court has control over you. Um, so and that depends on where you live. For companies, you can have two places where you have personal jurisdiction, where you're incorporated. It's called where you're domiciled, where incorporated, and where principal place of business is. Here, that was, I think, both in state C. Oh, A. Okay. So the railroad company, well, okay. Let's see what the answer choices are first, because there's a lot of different possibilities. So deny the motion because railroad company consented to personal jurisdiction by registering to do business. State C, deny because company waived the rights to challenge personal jurisdiction by failing to raise it in pre-answer. No, you can do it in, it just has to be in the first thing that you file. Grant motion because mechanic suit arose out of contacts with state A and B. Grant because railroad company incorporated and maintains principal place of business in state A. Okay. Oh, so automatically, I just want to say probably it's okay in state C because if state C requires registered companies to consent to jurisdiction, oh, yes, yeah. If state C requires companies, I think that's right, to jurisdiction in their courts. The reason I'm stopping is because he filed in federal district court. He didn't file in state C court. But I think I'm making that too complicated. I think state C still has jurisdiction over the this person. Oh, this is tough. I want to say it's A. I think it's A. I'm just going to say A because if I keep trying to explain, I'm going to get it wrong. Is it A? Yay! Okay. Oh, tip for putting short term. Oh, I need that. Read it as close to going to sleep and then again as soon as you wake up. That's actually really good because I do like doing things right before I go to sleep. Usually I'm answering questions, but I should review my flashcards before I go to sleep. That's a good tip, CH. Because literally half of this is just like memorizing. There's just so much to memorize. But I'm very happy I haven't, well, I guess I've kind of looked up a rule. Um, I think you have to remove the logical part of your brain to answer these questions. Yeah. No, that's why like originally it's like LSAT machine, but now that I'm doing like not LSAT stuff, I change it to law. But I always tell my students like for the law school admissions test and really for all these tests, you have to become like a robot machine where you really have to just like you can't think outside of the box that they like the things that they tell you. You really have to like suspend part of your brain. Okay, so that wasn't so bad. Um, okay, most people get 72%. I got 100%, but that was not very um fair. Okay. Do I have it in me to do another set? That was a lot. Yeah. All right, let's do it. Let's do it. More torture, more questions that I missed. Let's do it. I only take the test once, right? Hopefully. Okay. Um, okay, what are they asking here? Should this man's confession be excluded as violation? I do remember this one, but it's a good one for me to look at. Okay. Should he be excluded as violation of Sixth Amendment? So this is asking, should confession be excluded under Sixth Amendment? The sixth is your right to counsel. But it only attaches when jury is sworn in. Yeah. Or first witness sworn in if it's a bench trial. Okay. So this guy, he called his sister from jail and told her he'd been arrested. He did not bring up a lawyer, but his sister, so sister retained lawyer for a man in jail. Lawyer contacted the police and demanded to be present. To be present. Police, they basically didn't let him, didn't bring lawyer in, and gave the man Miranda warnings and questioned him until he voluntarily confessed. He never requested a lawyer. Police did not mention to the man a lawyer was trying to reach him. A lawyer was trying to reach him. At his arraignment, the man was formally charged with robbery. And then should the confession be excluded? Okay, the answer is no, because you have to request your right to counsel. It doesn't matter if a counsel lawyer is there and trying to reach you. The police don't have to tell you that a lawyer is trying to reach you. They have to tell you you have the right to a lawyer, and one will be appointed to you. One will be appointed to you if you can't afford one, but they have no duty to tell you that like a lawyer's been hired for you and they're trying to reach you. You have to actually request it. Okay, so let me look at my answer choices. And I do remember this one, but I mean, it's good that I remember the rule. No, because man hadn't been arraigned. Oh, sorry, that's not even the right reason. I stopped explaining. So no, you don't need one even if you aren't entitled to a lawyer until you request one, but your right to a lawyer doesn't begin until trial proceedings started. Since this was before his arraignment, it was just after he arrested, but before any proceedings started, he didn't have a right to counsel at that time. That's why. No, because man waived right to counsel. Yes, because lawyer had been retained. Yes, because police failed to inform man about his lawyer. Okay. I'm doing this a little bit from memory, but also I'm pretty sure it's A because yeah, the didn't attach yet. The Sixth Amendment rights to counsel didn't attach. Please let that be right. Yay! Okay. Let me make sure. Okay, so it seems like this is not right. I should take this away, probably. Only attaches when proceeding. So he hadn't been charged yet, and that's why he didn't have the right to counsel. Okie dokie. If it were a wife, would it be different? It's just it's just a sister. I mean, yeah, it's just a sister. If it's a wife, it still does not change it. He has to actually say the words like I want to have a lawyer present. And then, they will then, if they want to question you, they'll be like, okay, you have a lawyer who's here waiting for you. But yeah, they don't have to tell you no matter who hired him. Yep. Okay. All right. Next one. All right, this is about amending a statute. And oh, okay. I should just put this one up. Sorry, I was reading it. Okay, so this is about state amending statute and canceling a contract. So under the contracts clause of the Constitution, you typically a state can't pass any laws that interfere with its ability to. No, I don't think that's true. All right, this is another one that I'm just going to have to look up the rule for. All right, so what's happening here? There's an increase in sexual harassment suits filed by government employees. So state passed a law requiring all government employees to take harassment classes. Classes include videos. State contracted with a production company. Then state decided to create a handbook instead of using videos. The state amended the statute to exclude the videos and canceled its contract with the production company. And then was the state permitted to amend the statute and cancel a contract? Okay. This one actually not sure I remember what the right answer was, but yes, because production company had not yet started production. Yes, because state has constitutional authority to amend statutes regarding videos. I don't really think that's what the statute was about. No, because amendment impairs state's contractual obligation to production company. And no, because amendment was not substantially related to compelling government interests. Okay. I think I have actually something about the contracts clause in here. Yeah. Okay, there we go. Contracts clause, state legislation can't change contract rights after contract is formed. Is that what I said earlier? Okay, so at least I remembered that right. So here, there was a contract formed. Right? Yeah, they contracted with a production company. So I guess they couldn't do it. I want to say it's C. I'm scared it's not C and it's A. We'll see. Having you guys here gives me strength. Okay, let's see. Please be C. Yay! Oh, that was hard. I think I answered A the first time. All right. Good job, Tina. Okay. Oh, that's scary. It's just so hard because you just have to know that you're remembering the rule right. Okay. Alrighty. Let's do the next one. Okay. What's this one asking about? Subject matter, jurisdiction. Okay. So subject matter jurisdiction of federal courts, it can either be diversity, which is when you have plaintiffs, well, let's just do parties from different states, or it's a federal question, which means it's a claim arising out of federal law. Okay, let's see. And the claim has to be over 75K. So 3 shareholders brought an action in federal district court for violation of federal securities law. Okay, so 3 shareholders sued under Fed securities law. Since they're saying it's a federal law, I'm already thinking they have federal question jurisdiction. So you only need one, you don't need both. So the subject matter jurisdiction should be taken care of. Shareholders sought certification of a class of all, oh, never mind. I take it back already. Okay. Well, let's see. Shareholders sought certification of a class. That means they wanted to make it class action. Wanted to bring class action for everyone who bought stock during a 2-year period. The members of the class suffered damages that range from 75. Okay. Individual damages ranged from 75 to 65K. I think it's saying $75 to 65K. Total damages exceeding 3 million. Some members of the class are from the same state. None of the 3 shareholders are of the same state as the corporation. That doesn't matter. Okay, so like I said, if it's out of federal law, then you already have federal question jurisdiction. So the states don't matter. The amount doesn't matter. For class action, well, let me do the answer choices because there's a lot of things you have to have for class action. Does court have subject matter jurisdiction? not sure. Yes, because none of the three shareholders is a citizen of same state as Corp. I don't think it's that one because that doesn't matter. Yes, because action is based on violation of Fed securities law. Could be that one. No, because no member has suffered damages over 75K. That only matters for diversity jurisdiction, not federal question. No, because some members of the class are citizens of the same state as the court. Again, doesn't matter. So it is going to be, it has to be B. It has to be B. It must be B. It better be B. Please be B. Yay. Okay. Okay. Good job. Thanks, guys. This is so scary to do by myself. I hate doing questions by myself. It's so much easier. It just feels like your whole life is on the line every single time you choose an answer. Okay. This one is about amount of money someone is owed in a for takings clause. Okay, this is asking about the takings clause, which says the government has to give just compensation if they take your land or occupy it permanently, basically. Okay, so what's happening to this lady? Woman owned a condo, stopped paying her taxes, well, let's just say, had 15K tax debt. County foreclosed on the condo and sold it for 40K. The county retained proceeds. Well, they can't do that. After the sale, woman sued county to recover proceeds, asserting violation of the takings clause. Okay, I messed this up on a different question before, but the takings clause is just very, very straightforward. If they take your land, they have to give you just compensation. I don't feel like that happens all the time, but that's the rule. So what can she recover? Nothing. I'm just going to keep it nothing. 15K, 25K, 40K. Okay. Well, the county has to get their 15K. Yeah, Tina, I can't keep over what to do. So now they always say you don't have to do math on the bar exam. Already, I'm not liking this. Okay. 40 minus 10 is 30, minus 5 is 25. So I think it's got to be C. They can keep the 15K, but they have to give her the rest. Yeah. Okay, good job. Good job, Tina. Good job, guys. Good job, Andy. Awesome. So you guys could totally take the bar. Well, I don't know that you want to. I'll let you know if you want to. You probably don't, but I think I'm really lucky because I've been tutoring the law school admissions test since 2020. And before that, I was tutoring like the ACT and SAT. So my test taking skills are very good. It's for me, it's the memorizing everything. So that's really hard. Okay. What's this one asking? I really remember a lot of these, so I guess that's good. Can tape recording be played? Can recording be played in court? All right, well, let's see what's happening, and then we can decide. So someone sued for a hit and run accident. The plaintiff called witness to testify that he saw the accident and the car sped off as he said the license number. It says he accurately. Accurate license number into a recording device. The witness on the stand said no longer remembered the license plate number, but yeah, number, can the recording be played? Yes, it can be played. Well, why can it be played? It can be played because I think because he remembers it happening. So if you're so no, sorry, I'm starting and stopping. So I think it's going to be, let me put the answer choices up here. Yes, as a present sense impression. Yes, as a recorded recollection. Only yes, as present sense impression and past recollection recorded. No, because not a hearsay exception. All right. I kind of remember this one, so I'm already pretty sure it's C. And I already forget why it's, it makes sense why it's C, because it is a present sense. Well, whatever. I'm not going to sit here and try to make up rules. Let me just look it up. I'm pretty sure it's C. Yeah. Okay. So why is it C? Okay. So it is C because it describes, explains an event and recorded and was recorded while perceiving it. Okay, so this is a lot like if you, for example, like have a diary or a journal and you're like writing down what happens every single day, but maybe you don't remember exactly what you wrote down for a specific day. It's kind of like that idea. Like if it's written down while you're experiencing it, it is a present sense impression. It is a recorded recollection because it concerns a matter with that the witness has knowledge of, but insufficient recollection of. Testify accurately. Okay. Alrighty. Another one. Yay! That one was 63% was the average, and we got 100. Great job, guys. Yeah, you guys got this. Oh my gosh, Tina, don't even talk to me about the rulings in the Karen Reed trial. I swear I was screaming at the TV, YouTube screen, whatever. In the KR trial, Judge Bev wouldn't allow reading of notes, only one in memory. She was so obnoxious. She was terrible. Oh my gosh. Awful. Those rulings really did not make any sense. Okay. All right. Can I do another one? I think I can do another set of 4, I think. I mean, I got to do it for 6 hours, so most people would have already done a practice test again, but I'm pretty sure if I how many 12-hour practice tests can you take? Only so many times you can subject yourself to that. Okay. Let's do a couple more. Actually, no. Well, no, yeah, I'm gonna do it. I can do it. If I can watch Jolene for 5 hours last night, I can definitely push through. Okay. What's next? Okay. Um, okay. So they are challenging a seizure of drugs. Okay, let's see what happened. So, police officer had a valid warrant to arrest someone for credit card fraud. Valid arrest warrant for credit card fraud. They had probable cause to believe the woman was at a friend's house, so that's where they went. Um, Door was unlocked. He didn't find the woman, but he did find illegal drugs in plain view on the kitchen counter. Friend was charged with possession of illegal drugs. Friend challenged officer's seizure of drugs as unconstitutional. Ugh, I don't know. Okay, let me put up the answer choices and then we can talk. Will the court deny? So yes, because officer was attempting to serve valid arrest warrant and had probable cause. Yes, because officer saw drugs in plain view. No, because officers' search of the house was unreasonable. No, because the woman didn't have a valid privacy interest in the friend's house. I actually don't remember what I answered for this one. Um, okay. Well, the rule is if you are if you see something in plain view while you're serving, whether it's an arrest warrant or a search warrant, you can take it. Now the issue is that this was at a friend's house. I want to say I want to say I answered D for the first time because I don't know, I thought I'd get fancy, but I think it's B because the woman did not have a valid privacy interest. Um, hmm, I think it's B, and it's gonna be really hard to explain why, and I'm very scared. Is it B? Is it B? It's B. No. Ah, dang it. I knew it. Ah, I knew this one. I should have known this one. I bet you guys got this one right. Is C. It was unreasonable. Tell me why it was unreasonable. Okay. Um, oh, well, if I had known that rule, then maybe I would have known this. All right. So apparently, officer can't rely on arrest warrant to arrest or search home of a third party. I mean, yeah, that makes sense. He really needed to have a search. I guess he needed to have a search warrant for that house. Um, or so must have search warrant or exception. More than probable cause to search another person's home. Okay, fine. Yeah, you guys, I'm like, just take it. It was left out. Yeah, you guys have a better handling of the police state. I'm glad that you guys have the instinct to protect your civil liberties. I'm like, yeah, he could take it. Okay. Um, okay, they filed a motion for directed verdict, which is the same thing as a judgment of a matter in law or matter of law. Judgment for a matter of law. Anyway, it just means no reasonable jury could make an inference to find in favor of the other party. Okay, so let's see what's happening here. A consumer bought chicken soup can from the neighborhood grocery store. It was manufactured at a large manufacturer. 2 weeks after buying, ate it. Oh no. Buyer's son ate the soup and got sick. With botulism poisoning, which can come from defects in canned foods or temperature storage issues. Tests later confirmed that the can of soup was tainted with it. The buyer sued the food company for negligence behalf of son. She provided no direct evidence of negligence, but invoked the doctrine of res ipsa loquitur. Okay. Relied on res ipsa loquitur. Res ipsa loquitur is, this is my memory, the only way this could have happened is someone was negligent. So maybe you don't know. So for example, let's say like a piano falls out of a window, like onto someone on the sidewalk. You might not know who was in control of the piano. You might not know exactly what they did to make it fall out of the window, but somebody did something wrong, and that's the only reason a piano would fall out of the window. So res ipsa loquitur is like if you don't know exactly what happened, but the only way it could have happened is if someone had messed up. Okay. So she said this is that type of case. The only way it would happen is if someone messed up, which I guess it sounds like. Adopted a traditional standard for res ipsa loquitur and comparative negligence standard. Okay. So this is a comparative negligence district, which means I always get them mixed up. I'm pretty sure this means that the plaintiff can collect if under 50% at fault. Okay, then the food company filed for directed verdict. Okay, well, I do think, of course, 100% it seems like a reasonable jury could conclude that it was the manufacturer's fault. All right, let me look at the answer choices. Deny the motion. Canned goods do not contain bacteria in absence of negligence. That's not necessarily true. Deny because the food company was along the chain of distribution. I think it's, I don't know, I think it's that one. Grant because no evidence food company was negligent. Grant because res ipsa loquitur has been abolished in comparative, oh, has it? Comparative negligence jurisdictions. I don't think that's true, but I don't know. I think it's going to be B, because you can bring a product's liability claim against anybody who's involved in like the making, the selling, or distributing of the soup. Because if they grant the motion, that means that the food company wins without ever the jury hearing it. But I don't think that's fair. I think there probably is evidence a jury could find. So this just means that the issue would go to a jury. I think it's going to be answer choice B. I hope. I'm scared. I knew I should have been scared. Dang it. Okay. It was C. All right. Why was it C? Because something I obviously don't know. Why was it C? Why? Oh, dang it. Okay. I forgot something about res ipsa loquitur. Has to be under the exclusive control of the defendant. So if a bunch of people had control over something, it's not res ipsa loquitur. And because the soup can, it was touched by like the manufacturer, the seller, the distributor, it wasn't in the exclusive control. So res ipsa loquitur is not a valid claim. And because that's the only claim she made, that's why they can do the directed verdict. Okay. Okay. Yeah, CH, if they bought directly from the manufacturer, then it would be denied. Yeah, exactly. If just the manufacturer had denied it, yeah. I mean, sorry, if just the manufacturer had control over it. All right, I gotta remember that part. So res ipsa is not just but for this, it's also the exclusive control. Alrighty, I buy it, I guess. Okay. Next one is about robbery. And robbery is taking of someone's property off their person or in their presence by threat of force or actual force. It's essentially larceny, which is just stealing, plus battery, which is contact, like making offensive contact with someone. Okay. Oh, I remember this question. So husband and wife walking to their car. A man carrying a crowbar jumped out and said, "Give me your jewelry and money, or I will beat your car to a pulp." They gave the man everything. He departed. Later arrested for robbery. Is he guilty of robbery? This was a tough one. I know the answer because I got it wrong. But let me put the answers up here. No, because taking by intimidation isn't enough for robbery. No, because man only threatened to damage the car. Yes, because they had reasonable apprehension of property damage. And yes, because man intended to deprive them of the money and jewelry. Okay. I already know what the answer is to this one. Yeah, Andy. It's if I remember right, it's answer choice B because he didn't threaten to hurt them. He threatened to beat the car to a pulp, not to hurt them. And it's about force against them. I'm pretty sure that's right. Yeah. Annoying. Okay. That one I just remembered because I thought it was very annoying. 43% people got that one. I mean, battery, not car battery. Yeah, exactly. Okay. And then last one here. Is this a farting one? Oh, Andy. Were you guys here when I was talking? There was a good one about farting. um, it was a politician had gotten medicine prescribed by a doctor, and one of the side effects was excessive gas, and the doctor didn't tell him, and he went and made like a State of the Union or whatever, and he was just farting crazy, and they were asking, can he bring a successful suit against the doctor? um, I can't remember. I'm pretty sure no. I mean, I can't even remember what the options were, but I just remember it was a farting question. Did I take a screenshot of it? Let me see. Actually, might have taken a screenshot of it. I thought it was very um did I take a screenshot? Yes. Um so the politician suffered from social anxiety that gave him panic attacks. He was going on a campaign tour and the doctor prescribed him something called Calm X. Um, the makers of Calm X had warned the doctors about the side effect of extreme flatulence when patients consumed a rare imported cheese while using the drug. The instructions did not warn consumers about the side effect that happens when they eat this rare imported cheese. So he took the medicine and went on tour. On the day of a critical televised debate, he consumed a large amount of the rare imported cheese. And as a result, he experienced extreme flatulence during the debate. The video of the debate went viral and caused him to lose the election. So he brought a strict products liability action against the manufacturer. And I honestly have no idea what the answer was for that one. I mean, no. Because if your doctor doesn't tell you about, if they don't, if the manufacturer doesn't properly warn you, um, then that is a claim. But I don't think losing an election to farting is the type of injury you can sue for. But I actually can't even remember that question. Maybe it'll come back up. Oh my gosh. Yesterday, what was the one CH yesterday? Oh yeah. Like a girl was like um paying for school by like selling meth. They come up with the craziest things. I would think that would make him win the election. You would think, right? It's so relatable. Makes him more relatable to the boomers. Exactly. Exactly, Andy. I know, bar exam, get over yourself. They're having too much fun, Andy. Way too much fun with this. It does sound like a personal problem, Tina. Okay. This next one. Um, this one is about appealing a motion for judgment as matter of law. Okay. Law, granted if no reasonable jury could rule for the other party. Okay. What happened here? A mayor sued a blogger for defamation under diversity jurisdiction. Um, Fed court under diversity jurisdiction. Um, the mayor said the blogger had published statements suggesting she was an adulterer. The mayor's entire case rested on her testimony establishing the elements of her claim and a properly authenticated copy of the alleged defamatory publication. Okay. Um, entire case was mayor's own testimony and copy of the article. Um, the blogger filed for judgment as a matter of law after mayor presented evidence. The judge found that the mayor's evidence wasn't enough for a reasonable jury. To find that the publication was false as required by state law. So judge granted the motion. Mayor appealed. Said judge applied the wrong legal standard. All right, I think I have to look at the answer choices for this one. So, should judgment be reversed? No, because not clearly erroneous. No, because mayor failed to meet her burden. Yes, because can't be granted until both parties have presented. Yes, because district court improperly evaluated the weight of the evidence. Oh, this is kind of hard. Okay. I don't think it's So for judgment, it might be D because the judge is supposed to decide whether the evidence is credible enough to show to a jury. The judge doesn't decide the weights of the evidence. So if the judge is just simply saying that the mayor's testimony isn't persuasive enough, I guess that's kind of like the weight, because it's possible that a jury could find it. B, I don't think she failed to meet her burden because they said that I mean, I don't think she failed to meet her burden because she established all the elements. I don't think it's C because you can grant it after just one party has presented. I don't think it's A because clearly erroneous usually has to do with evidentiary rulings, like when you say something is admissible or not admissible. I want to say it's D, but I'm not sure. Let's see. Yay! Only 19% of people got that question right. Great job. Awesome work. Yay. That was a hard one. Yeah. Nice. Okay. And I am done with that set. That was okay. Well, most people only get 36%, and we got 50%. So that's something. Okay. Let's see. Is my performance going up? Yeah. All right. Now I've got to take a break. Thanks to you guys so much for hanging out with me and supervising. This was actually taking so much longer if I did it myself. Yeah, I might be back on later, might be on tomorrow. I'm kind of sad because I won't be coming back on. I mean, I have no reason to come back on after I take the test. What is the passing score? Kelly, I'm pretty sure I don't even know. I'm pretty sure it's like just over half. What is the passing score? I don't even know. So it goes up to 400 and you have to score at least a 2. Oh, shit. New York? I don't know. They had different numbers. Oh, New York's going to be hard. Okay. Is it New York? No. Okay. I have to get a 266. Yeah. Hmm. Yeah, I think I have to get 266 out of 400. And there is multiple choice questions. There's essays, which I might come live and do a couple essays. And then there's another one that's you have to basically write a memo or like a letter. Like you get a bunch of facts and you have to read the cases and use the cases to write a persuasive argument. So it's like 12 hours. Okay, thank you guys so much for supervising me. I definitely needed it. If I'm not back on today, then I'll see you guys in another chat. Really great work, guys. I feel like I want to say good job because you totally helped me. I hope you guys have a good rest of your afternoon. I tutor essays and I actually just got my first, because we have the company I'm doing bar prep with, they have graders who grade the essays. And I got a really good score on my last 2 essays. Like he had no notes. So maybe I should come back and do an essay just for some confidence. Yeah. Yeah. The me know, Andy, because I don't like doing them by myself. All right, guys, I hope you have a good rest of, oh my God, it's 4. Well, I'm in Eastern. All right, guys, I hope you have a good rest of your afternoon. I'm sure I'll see you somewhere else. I'll talk to you later. Bye.